that Jake? Are you taking care of that? Okay. So when we go in for the meeting, everyone, when we go in for the meeting, Sue is going to kick it off, and then I'll probably ask a question or two, and then Keenan from One Iowa has a question to ask. But are there other people that want to ask a question of Grassley staff?
You are.
Perfect. Okay. Wonderful.
Thank you.
What should they actually use for this report? Probably a question. Like, are we covered?
Lance was actually with. Hi there, I'm Carol.
Whatever you want.
Nice to meet you, Sue. Thank you. And so if you're, and I'm going to ask them to probably just briefly provide you an overview of the process of how it works from Senator Grassley's responsibilities on the Judiciary Committee, and then to be available for you folks to ask questions.
Is this Carol again, or is this somebody else?
Yes, this is Carol. Thank you so very, very much. So we have a group
Kenny here, and I'm also with Catherine Willie. We're both on the Judiciary Committee Nominations Unit.
Thank you so very much. We have a group of, I don't know, maybe 30 people, 30 or so people, and we were going to be able to get some more chairs perhaps out of that.
It's okay.
And so, Steve and Catherine, perhaps if you could first spend just a few minutes talking about the role of the Judiciary Committee as it relates to the process of about judges, because I know there's the nomination process and there's the confirmation process, and then perhaps then we can have a couple of questions. And if you want to ask a question, I'm going to ask you to perhaps move closer to the table so that we can get a microphone. We have you on a speakerphone, and I believe that we can all hear you pretty well. And so I'm going to have you just go ahead and get started. Thank you.
Would you mind if I kind of introduce?
Yes, that would be fine. That would be good.
Well, I'm Sue Dinsdale, and I want to thank you for inviting all of us in here today. It's a pretty good crowd. We're part of the White Courts Matter Coalition. And we're not lawyers, some of us might be, but we are affiliated with different organizations that believe and know that our courts affect all of us. So we're all in Des Moines for a convening. This is our 5th annual. And we actually had 67 individuals come in from 17 states. And part of our mission is that we need judges who represent and protect the constitutional rights of all. So we really appreciate you letting us in, and we'd love to hear from the Judiciary staff.
Well, Stephen, was that your name?
Yes, tell Ted hi for me.
Well, it's a pleasure to speak to all of you. So a basic rundown of the process, which I'm sure you're mostly familiar with, is that the Constitution provides for the Senate to provide advice and consent to the President on nominations, both to the executive branch and to the Judiciary. So as part of that role, the Senate Judiciary Committee is in charge of vetting all of the judicial nominees and a number of executive branch nominees, including Senate confirmed positions in the Department of Justice, U.S. attorneys, U.S. marshals. And so once the President has made a nomination, then the nominee sends over a number of materials, most primarily the Senate Judiciary Committee questionnaire form, which is a very thorough questionnaire, goes through all of the nominees' prior materials. Both the majority on the committee and the minority have the opportunity to review this. Once they've had that opportunity, the nominee is then scheduled for a nominations hearing, which gives all the senators on the Judiciary Committee a chance to ask the nominee questions about his or her record. Once that has occurred, there's a week for senators to submit questions for the record that the nominee responds to, and then the nominee is up for a vote in the Judiciary Committee, and then assuming that the nominee has been approved by a majority of the committee, is then sent to the floor to await final confirmation.
Great.
And so, as you might know, Senator Grassley has been chairman for the past two Congresses, as the Republicans have been in the majority.
Right. I think there were some folks here that maybe had a question or a comment that they'd like to pass along. So, Matt Sanovic?
Sure. Thank you all for taking the time to meet with us today or join us on the phone. My name is Matt Sanovic. I'm the Executive Director of Progress Iowa, and have been working on this issue for the last several years. In fact, one of the first years we were on was when Senator Grassley became the chair of the Judiciary. At that time, it was under President Obama, and we've heard and know the process that you just laid out all too well. I feel like this has those steps that you described when President Obama was in office. Those were used as a way to delay and slow down nominations. Judicial nominations, and now what we're seeing, unfortunately, over the last year and a half is that you have sped up that process, sometimes skirted either the blue slip process, the questionnaire, kind of sped along in order to push through those nominations at, in fact, a record pace. And so there's a lot of frustration in this room with how that process moved forward, because we feel, and Iowans feel, that the senator has abdicated his role as a check on the executive branch. So I want to express that frustration and ask that you pass along that message to the senator that Iowans really want him to be a check on the president. We don't expect him to be a rubber stamp. We expect him to represent us and not just pass through judicial nominations without doing his due diligence.
So hey guys, I'm sorry I'm late. This is Mike Davis. I was running late from another meeting, but I'm just getting in here. And I appreciate your taking the time to talk to us about the nomination process. And I understand that Steve Kenny and Catherine Willey have talked to you a little bit about the process. I would just want to make the point, Steve's going to talk about the blue slips, but I would just want to make the point about the rubber stamp. We hear that charge a lot, and I just don't think it's true. If you look back in December, there were 4 nominees, actually 5 nominees, who were not renominated by the president. 2 of them were Chairman Grassley, Senator Grassley publicly called on them to withdraw, and then 3 other nominees, there was a private discussion, so their nominations were not resent. So those were 5 nominees. That's a significant number of nominees. So I just want to point back, push back a little bit on the rubber stamp.
And I guess we push back that those nominees made it through Chairman Grassley's committee on a partisan line vote. So you actually pushed him through those nominees through committee before they were stopped by the full Senate.
That's actually not true. There was there was a nominee on the floor, and then we found out about the blog posts after the fact, after the committee hearing, and then after that came out, we called on that nominee to withdraw. The other nominees were processing through the committee. One of them was Matt Peterson for the district court in the district of the district court out here in D.C. And Chairman Grassley called on him to withdraw his nomination after his hearing. Brett Howley was the nominee for the federal seat down in Alabama, and he did not disclose his blog post, and we did not learn about his blog post. No one learned about his blog post until after his hearing.
But isn't that exactly the point of the Judiciary Committee process? That if you're going slow and taking your time and learning their
actually,
records?
if you look at the process, we followed the traditional process that has been followed by almost every chairman. What happens is the nominees have to fill out their Senate Judiciary Committee questionnaire that we review. They are reviewed by the nominees are reviewed by the White House counsel's office. They're vetted through the FBI. They're vetted through the Department of Justice. They're vetted through the home state senators, and they're vetted through the Judiciary Committee. This is an instance in this case where this nominee failed to disclose this blog in which he was using a pseudonym, and it was not disclosed. It was not discovered through any part of the vetting process, and it would not have been discovered but for the fact that the nominee went online and claimed that it was his blog after the process. So we would not have learned about that. I mean, I get your point that there's this perception out there that we're rubber stamping or jamming these judges through the committee, and it's simply not the case. There is a vigorous vetting process that goes on here, and there are dozens and dozens and dozens of nominees who no one ever hears about in the public because we kibosh their nominations before they even are nominated.
I think, just to push back again, someone who knows the specific numbers can chime in if they have them, but you can come up with any specific example of a nominee or a handful of nominees being rejected, or when President Obama was in office, nominees moving forward. But the bulk and the big picture of the work that's being done in the Judiciary Committee is, on the whole, the concern that we have, the concern that Iowans have, is that it's political, is that he has taken the Judiciary Committee and politicized it, whether it was slow-rolling nominees under the Obama administration or fast-tracking nominees, or however you want to call it, under the Trump administration. And the numbers of the record few amount of justices or of nominations moved forward under Obama, and the record number of nominations moving forward under Trump paint that picture better than any one specific example can. And so that's our frustration, and that's our call for Senator Grassley to do his due diligence and be fair-minded, uphold the Constitution, and not politicize the committee.
I think he has. I think he's done all those things, as 5 nominees in December just learned the hard way.
Well, and I, as somebody who is here for both the end of the Obama administration and this administration, will certainly pass along your concerns to Senator Grassley, but I would just like to know our vetting process has not changed. It's consistent. We are really working through all of these nominations. It's not an easy task. It wasn't an easy task under either president, and we were very mindful of pace and keeping the pace consistent. So, but we will certainly express your concerns.
I would like to, maybe I can email this to one of you guys. I would also like to point you to the last markup meeting that we just had, where the Senate Democrats profusely praised Grassley for how fair and even-handed he has been as the chairman of the Judiciary Committee. And that didn't come from just one of the Senate Democrats, it came from almost all of them. They were praising him for his fairness, his even-handedness, how he's led with principle on the committee, and while they may disagree with him on political matters or ideological matters, they were praising him for being fair and principled.
Can I ask you to help me understand the fairness of treatment and the principle behind the 7th Circuit vacancy from Wisconsin? Because as you all know, that vacancy sat open for 6 years under President Obama, and in part because Senator Johnson withheld his blue slip and he had a home state senator objection, which was respected under Pat Leahy, and Senator Grassley said that he would also adhere to the blue slip while Obama was president, and then gave his word that he would adhere to the blue slip under Trump as well. But the minute that that Michael Brennan was nominated for that seat, and interestingly, Brennan worked with Johnson to advocate for keeping that seat open for himself. He wrote an article about how that seat needs to the objection should be adhered to, because anything other, if they were to schedule a hearing over Senator Johnson's objection, that would be, in his words, purely partisan politics. But now he's the very nominee who helped keep that seat open for himself. And the issue is, this is not a situation where Michael Brennan is such a consensus nominee that Senator Baldwin's now objection is unreasonable. Because as I'm sure you know, Michael Brennan did not get through Senator Baldwin and Senator Johnson's bipartisan commission, which they agreed all of their nominees must get through. And he was announced and pushed through, and now Senator Grassley has decided that he is going to not respect the home state senator's objection when that home state senator is a Democrat, and he's going to fill that vacancy. But while he did respect the home state senator under a Republican. Can you help me understand, as somebody who advocates, how is that fairness? How is that even application? Can you help me understand why there's a different set of standards and how that's not politicization of the Seventh Circuit Court of Appeals?
Well, I would note that, in fact, President Obama's nominee, Donald Schott, did get a hearing under Senator Grassley and was voted through the committee. It was on the floor where he did not receive a vote, and his nomination was returned to the president at the end of the last Congress.
And I understand that, and that's an issue with McConnell's office. However, that still doesn't explain why it is that Senator Grassley scheduled a hearing for Michael Brennan over Senator Baldwin's objection when his rule that he said and that he stated that he was going to adhere to has been applied differently depending upon who the administration, if you have an R or a D behind your name. And I have to tell you, it feels very much, as somebody who practices in the federal courts, feels very much that the clients who use those courts are having those courts being politicized, and there's no question about it. I mean, this is a plain and open and obvious example. And I have to also tell you that I'll take off my advocate and lawyer hat for a moment, and I'll put on my mom hat, because I do have 2 daughters at home, and it's really hard to explain to them how, you have to play by the rules. What's fair is fair, and when it's your team's at bat, you can't change the rules and cheat to win the game. So I have, there's a lot of issues that come up with the current way that the leadership is handling this. What's good for the goose is no longer good for the gander. And that's, I think, the frustration that you see around the country, you see among Iowa, you see among federal court practitioners. And I still have never heard, and I would love to hear it from you, a very clear answer on why what is good for Senator Johnson is not good for Senator Baldwin. So that's the question that I'd like answered, not the one about McConnell. If you could please answer.
Well, yeah, it has nothing to do with Senator Baldwin versus Senator Johnson. And I'm happy to send you some of the materials we have on this, but Senator Grassley has made numerous public statements about his approach to the blue slip. And his policy is consistent with 16 of the previous 18 chairmen. I'm sorry, I'm getting an incoming call here. Sorry about that. His policy is consistent with 16 of the previous 18 committee chairmen. It was only Senator Leahy and Senator James Eastland from Mississippi who had policies that strictly required 2 positive blue slips before they were willing to hold a hearing on the nominee. So it is Senator Grassley's policy that is consistent with the vast majority of historical practice. Now, he himself has made a distinction between circuit court and district court nominees. And he has said that, a circuit court governing multiple states, it makes less sense to defer to the desires of home state senators than it would for a district court nominee, where obviously the entire court is within one state.
But this is the same vacancy. It's the Seventh Circuit Court of Appeals. There's absolutely no difference. And it's the same, you don't have 2 senators. You had Senator Baldwin and Senator Johnson. And under when Obama was president and Victoria Norris was nominated to that seat and Senator Johnson objected, Senator Grassley said we're going to adhere to the blue slip. And
I'm sorry, Senator Leahy was the chairman at that point, and his blue slip policy was very strict. I will grant you that.
Senator Grassley, I'm sorry, you're right. But
Senator Grassley, Donald Schott, who was the nominee when Senator Grassley was chairman, Donald Schott got through committee.
And because Senator Baldwin did not have an objection to him. But it's just, he adheres to the blue slip.
Senator Johnson did return his blue slip, even though Senator Baldwin violated the agreed upon charter for their Judicial Selection Committee.
But Donald Trump had gotten through their bipartisan commission, which Michael Brennan didn't. And all we're asking for is just the even-handed, what's fair is fair. And I think you will agree with me. I don't think you're trying to suggest that Grassley did not strictly adhere to the blue slip while Obama was president, while he was chair. I think we all agree and understand that that Grassley adhered to the blue slip under those circumstances. And so what I'm asking you now is, now that Trump is president, why isn't Grassley sticking to the same standard that he stuck to under a Democratic president? And that's what we'd like an answer to, but we would like you to relay to Senator Grassley that we would like to see that what the rules are the rules, what's fair is fair, and adhere to the same rules that you adhered to when a Democrat was president.
I would like to point out, I don't know if this was discussed before I came into the room, I would like to point out, if we talk about the rules being the rules and what's fair is fair and goose and gander and all the other talking points you have, I would suggest that you look back to 2013.
I just want
when we
Senator
had
Grassley
a
to.
filibuster for judicial nominees that the Senate Democrats blew up so they can stack the DC circuit. And so now the Democrats who thought it was unfair for 40 senators to block a judicial nomination, now they want one home state senator to be able to block a judicial nomination for a circuit court that covers more than one state. So, I don't think that, I don't think there were clean hands by the Senate Democrats here. I think they have buyer's remorse now because they blew up the filibuster for circuit court nominees back in 2013, and now they're trying to reverse their position by making these blue slip arguments. Chairman Grassley, as Steve said, has a consistent policy that he is following the blue slip policy of 16 of his 18 prior predecessors. And I will point out that was left out of this discussion. The two prior chairmen who had a strict blue slip policy, I want to talk a little bit about their strict blue slip policy. Chairman Eastland was a Southern Dixiecrat chairman. And the reason he had a strict blue slip policy is so he could block federal judges who would apply the law in Brown versus Board of Education. So the racist roots of Chairman Eastland's blue slip policy is strict blue slip policy so he can block judges who would implement Brown versus Board of Education. Chairman Leahy had a strict blue slip policy during the Bush 43 administration because he used it to block President Bush 43's judicial nominee.
Do you not find it ironic that now Chairman Grassley is using the same process as before to put through nominees that won't answer whether or not Brown v. Board of Education was correctly decided? 2 of the past 5 nominees that have gone through committee hearing have failed to answer the question of whether or not Brown v. Board of Education was correctly decided. Do you not find that problematic, sir?
I think every one of the nominees would say that, and actually, Mrs. Bitter testified to this. If you listen to her full testimony, they both said that racial discrimination is repugnant and wrong, and segregation is repugnant and wrong. What their position is, and this is the position that they think that they have to take because of their judicial ethics, is that they are not going to come in here to a judicial nominations hearing and make promises on how they're going to rule on cases, or come in here and grade the Supreme Court and say what cases are rightly or wrongly decided. As a lower court nominee, a circuit court nominee, or a district court nominee, their answer is that every single current precedent of the Supreme Court is rightly decided because they're bound by it, and it doesn't matter what their personal views are. So I think it's cheap political games and cheap racial politics what's going on with this Brown versus Board of Education discussion. The argument is that these nominees are somehow, like they somehow are bigots and racist and segregationists because they can't come in here and answer what cases are rightly or wrongly decided. And it's the gutter politics that should not be involved with judicial nominations.
Well, speaking of racism and segregationists, I'm from North Carolina, and everyone that I've talked to in North Carolina has serious concerns about one specific nominee, Thomas Farr. Thomas Farr was a mentee and a law partner with a guy who was a white supremacist. He gave a speech in 2007 praising this man, and now he's going to get a lifetime appointment to a seat in North Carolina where nearly a quarter of the state's African-American population lives. He's also got a long history of voter suppression, and if you ask me, that's just an attempt to put white supremacy on the bench, and that's something that is just completely unacceptable.
Well, I think that the whole premise of your question, to the extent that that's a question, to say that someone is a white supremacist is a pretty strong allegation to make, and to me it sounds like you don't want to have a serious conversation.
Well, I want to have a serious conversation because, like I said, this man's law partner was a white supremacist. He was on the board of directors of the Pioneer Fund, which funded research into genetic differences between white people and black people to argue that white people were genetically superior. That's the very definition of white supremacy, and that's the kind of guy that Trump is putting forward.
I'm going to switch gears real quick.
You know, this is the first time I've heard this allegation about the partner and the funds. That was not raised one time during the nominations hearing. It was not raised by anyone, including the Senate Democrats, during the questions for the record after the hearing. This is the first time I've heard this.
Well, I believe it was mentioned by several advocates who submitted letters about this to the committee, but I don't have those in front of me.
Okay, well, the Senate Democrats did not raise this issue one time.
We're not Democrats.
Why does it have to be those senators that raised that issue?
Because they're the ones at the hearings that ask the questions. So, you certainly can submit letters, and we read all the letters. This is the first time I've heard this allegation.
Those letters are in the congressional record. They were submitted by various advocacy groups.
Okay, well, this is the first time I've heard this allegation.
So if Democratic senators would like to ask questions now, would you allow Thomas Farr to come back for a second hearing? I know that Senators Harris and Booker, who did not have a chance to ask questions because they were not on the committee when Farr came before the committee first, have questions, and there have been other questions raised about whether or not Mr. Farr was honest and accurate in his testimony. Would you provide another chance for these Democratic senators to ask their questions?
They've had their opportunity. What the standard practice is for senators who join the committee during sessions of Congress is, and this is the historical practice, is they're allowed to submit questions for the record. When Senator Harris and Booker joined the committee, Chairman Grassley extended that same courtesy, and it's a courtesy, it's not a rule, it is a courtesy that was extended by Chairman Grassley to Senators Harris and Booker. And they were appreciative of that, they submitted their questions, and they got their answers.
So you say that Democratic senators should ask questions, but now there's no further opportunity for them to ask questions. I don't really understand that.
They have the opportunity. They have the opportunity to ask their questions, and they ask their questions, and they got the answers to their questions.
Oh, so since the opportunity's passed, even though they haven't had a floor vote, they're no longer allowed to ask additional questions?
They had their opportunity to ask the questions. I'm not understanding what you're asking. Do they still get asked questions? Is that what you're saying?
Yes, because we just discussed the Pioneer Fund, and you said that Democratic senators didn't ask questions. I'm saying that what if they want to ask questions now, would you provide them that opportunity? I believe this information may have come to light after the hearing.
They're out of the committee right now. They're on the floor. The senators can send a letter to the nominees anytime they want and ask any questions they want.
Yeah, so I'm part of a group that represents LGBTQ Iowans, and I've heard from quite a few of them about being extremely concerned with some of the nominees that have been going through the commission or up for hearings soon. So for instance, Kyle Duncan, who's already cleared, and Mr. Gordon Giampietro, who is coming up soon. And so, for those of you who may be married, if somebody publicly described your marriage as an assault on nature, would you feel confident that that judge could represent your interests fairly in a courtroom?
So you bring up a good point about Mr. Giampietro from Wisconsin. He is a nominee for the district court in Wisconsin. He was recommended by Senator Tammy Baldwin to the White House. He was one of 4 candidates who was recommended to the White House. And the White House chose him after Senator Baldwin recommended him. She has since said that she is not returning a blue slip. And Chairman Grassley is not scheduling a hearing for his nomination because she has not returned her blue slip. So it shows that he has a consistent policy, and it's just as he described for the circuit court nominees. So long as there is consultation with home state senators, Chairman Grassley will schedule a hearing, and the home state senators cannot use political or ideological reasons to block circuit nominees. Chairman Grassley is more deferential to home state senators for district court nominees. Hence, there is a difference with Mr. Giampietro's nomination.
So just to clarify, that is a
he's
change.
consistent and principled, and he's not political.
Okay, so just to clarify, that is a change in position of Senator Grassley since the,
Not a change of position.
well, no,
Not
it's
a change of
the change of
It's just
position on the
they
circuit
would-
court nominees.
maybe not
If
what
you let her
want to do,
finish,
but
she'll
not a
get
change
to
of
the.
position.
Okay,
what she's
I'm just
saying.
trying to ask this, it is a change in position from when the Seventh Circuit Wisconsin vacancy was not, there was not scheduled a hearing for the Obama nominee. It is a change in position.
No, again, there was a hearing for Donald Schott, and he was sent through
But that
committee.
doesn't deal with the blue slip. So are you I just want to clarify, is it your position that while Senator Grassley was chair of the Senate Judiciary Committee and Obama was president, that he had flexibility with regard to the blue slip, or did he always adhere to it?
Well, he always adhered to a strict policy of requiring 2 positive blue slips for district court nominees.
And circuit court
but
nominees.
he had never announced a policy regarding circuit courts that he would continue Senator Leahy's strict blue slip policy.
Can you tell me an instance where he ever held a hearing on a circuit court nominee while Obama was president where both home state senators didn't return the blue slip?
Well, there were a few nominees that did not come over until 2016, which was a presidential election year. So there's a rule called the Leahy-Thurman rule, which is that the Senate will typically not confirm nominees starting at around the time of the political conventions over the summer. So the nominations just simply came too late for the Senate Judiciary Committee to go through its process and send them to the floor, and they would not have received confirmation.
Okay, so we're in
If
agreement
you
though.
recall, Senator Grassley waited 7 months before holding a hearing for David Strass, giving home state senators the time to return the blue slips. He didn't just, go on and run Al Franken over. And he would have afforded the same courtesy back in 2016.
I think we had a couple other folks. Did you have, someone else have a question or comment? Yes, go ahead.
My name is Jamal Watkins, representing folks from the NAACP. And I know as much as the senator and folks would like race issues to disappear, what's troubling about what we're seeing in the nominations process is that Donald Trump's nominees are, pretty much 90% white, and that's a higher percentage of nominees in that category than any other president than, say, over the last 30 years. The data and analytics shows that. And what's deeply concerning about this is when you think about issues of race and class and representation, it's the notion that, and I know folks were debating this earlier, but in his first year, Donald Trump got 23, I think, Article 3 judges through, in comparison to Barack Obama, President Obama's 13. That rate is actually a higher rate. The numbers prove it. And so when you start to look at the dynamics, the question for communities of color who are growing demographically day by day, every single day, in terms of on the voter rolls is where is the fair representation in the courts through this administration, and what does the Judiciary Committee, and in particular Senator Grassley, what is his position on making sure that the representation is actually balanced in terms of what the country looks like?
So I agree with you that that diversity is very important, and our court should reflect who we are as a society. And so I agree with that premise. So Chairman Grassley's job as the Judiciary Committee Chairman is to kind of manage the process once the nominees are picked. His approach is he does not want to Bigfoot this process. He thinks it's very important for the president to work with home state senators to pick these judicial nominees. And diversity is very important in this process. And it's unfortunate, frankly, that we're not seeing more diversity in the judiciary. I will say this, it's an issue that has been raised with the White House counsel's office repeatedly. So I do appreciate the concern there. I will say this: there have been, if you look at the nominees who have been confirmed so far, we're at 33 nominees, 33 judicial nominees confirmed so far. And if you look at these nominees, Four of these are female circuit court judges. One of them is Judge Amy Barrett, 7th Circuit in Indiana. There's Judge Joan Larson, who's a native Iowan for the 6th Circuit in Michigan. Judge Allison Ide for the 10th Circuit in Colorado. Judge Lisa Branch for the 11th Circuit in Georgia. If you look at these nominees, at that same point when at that same point in President Obama's first term, when we had 4 female circuit court nominees confirmed during this Congress, there was only 1 during President Obama's first term. So that, at least from that perspective, they're not behind, but there's still a lot of work to do. But let's look at some of these nominees. Judge Amy Coney Barrett, she's a former Notre Dame law professor. She's a Catholic mother of 7. She's adopted 2 of those children from Haiti. There's Allison Ide. She was the first female judge to hold that 10th Circuit seat in Colorado. Judge Joan Larson. Actually, all three of these women were Supreme Court clerks for the U.S. Supreme Court. There's Lisa Branch, as I said, who is on the 11th Circuit down in Georgia. We can also talk about some diversity on the district court. Judge Karen Scholler of Texas. She was confirmed in March. She was born in Tokyo to a Japanese mother and American father. She's the first Asian American woman confirmed to a district court seat in the entire 5th Circuit. There's current Magistrate Judge Terry Moore, who will be the first African American to serve on the Southern District of Alabama once he's confirmed. There is Amul Thapar. He's the first ever Indian American federal judge when he was confirmed in 2007, and he is now the first ever Indian American to serve on the 6th Circuit. There's also James Ho, a former Supreme Court clerk. He immigrated to this country from Taiwan as a toddler, and he's the first Asian American to serve as Solicitor General of Texas, and he's now the first Asian American to serve on the 5th Circuit. John Nalbandian.
Yeah, well, with all due respect, I don't mean to cut you off, but it feels like, in the world that we live in, it's like saying, oh, I have black friends, let me point to them and name them and talk about their attributes. What we're talking about is rates and ratios, and when we look at the numbers, there were 10 judges who were of color that were replaced by the Trump administration in this process who are not replaced by people of color. And so the rates and the ratios is what I'm talking about that's problematic. Not that you have 1 or 2 shiny beacons that you can point to say, look, we have friends of color who we've placed in these positions. It's completely off center. And that's the message that we want to get to Senator Grassley and clearly to the Judiciary Committee. That's the problem we're talking about.
Well, I'm sorry what I just said didn't fit into your narrative, but what I was trying to explain to you, and there's a couple more that I can go into, that, as I said, that we need to do more as a country on race, for sure. The judiciary does not reflect who we are. The judiciary does not reflect the racial composition of this country, and we need to do a better job. I acknowledge. What I was trying to point out to you with very specific examples is there is diversity in the judiciary. Maybe it's not as good as it needs to be, and we have a lot of progress, but there is diversity. And I think that as advocates, if you want to be credible, when you come in with your concerns, you can at least acknowledge, where the other side has done some things that are good, if you want to have credibility when you're talking about, the issues that you want to raise. Otherwise, you just sound ideological and partisan, and there's no point to the conversation.
Well, I mean, and I'll close here, not to get into a catfight with you about partisan ideology. I'm not a Democrat, I'm an independent. But when we talk about, credibility, my credibility is within my community, and what we're conveying is that is the fundamental concern. And we can acknowledge that progress has been made. Yes, lynchings have stopped in this country. Yes, African Americans have the right to vote, but it doesn't mean that we've achieved where we need to be on the pace that we need to be. And so that, again, is the crux of what we're talking about in this space, and that's what we want conveyed to Senator Grassley.
As I said, I agree with you that we have a long way to go.
Ironically, we actually got pretty close under President Obama, so it's really unfortunate that we're now regressing to really not great levels of diversity, gender, ethnic, racial on the bench. And it's not that we're just not getting there, we're not getting there right now. Under Chairman Grassley's leadership and under President Trump's leadership, they've regressed to 30, 40 years back from where we were before.
I think that's a terrible cheap shot against Chairman Grassley, and it doesn't surprise me that you would say that, but it's a terrible cheap shot that you would say that. What I think that you guys should do, if you're concerned about diversity on the bench, is I think that you should go to these home state senators, including Senate Democrats who have a say in these district court nominations, and ask them, why are you not recommending more women and minorities for these district court slots? Why are you not recommending more diversity?
Well, actually,
I
the
mean, that
vast
is a
majority
function
of these
of
nominees
the
that came
president
up at
with
the
the home state
beginning,
senators.
the vast majority of these nominees that came up at the beginning came up in states with 2 Republican senators. So the vast majority of this lack of diversity has come from states with 2 Republican senators and have been pushed through.
And there are a lot of nominees in the pipeline, and I think that this is something that needs to be addressed on a bipartisan basis, that home state senators on both sides of the aisle need to do a better job of recommending district court nominees that recommending more women and more minorities for the district courts.
That is no doubt, and we are speaking with Democratic senators about this as well, but that does not absolve the chairman or Republicans for their complicity in this.
How is Chairman Grassley complicit in this? I'm very curious.
One thing I think we could ask of Senator Grassley is to, because I appreciate your concern and acknowledgement that this administration can do better in diversifying the courts.
It's not just this administration, it's this administration and the home state senators across the political spectrum.
Understood.
They need to do everyone in Washington, D.C., Democrat and Republican, need to do a better job of recommending more women and minorities to the federal bench.
Sure.
Sir, with all due respect, that is not necessarily a piece within Article 3. It's the president who makes the nominations. This is a...
You guys were just complaining that Grassley was ignoring the blue slip of home state senators. That's how the home state senators... The blue slip is not mentioned in the Constitution, but you guys were complaining about Grassley's blue slip policy. The blue slip policy ensures that the president consults with home state senators. And I just told you that Senator Grassley is almost certainly not going to run over a home state senator on a district court nominee. So therefore, the home state senators have a lot of sway over district court nominees. Senators across the political spectrum, Democrats and Republicans, need to recommend more women and minorities for the district courts.
Well, Myra
That's how we're going to change the diversity.
Myra Shelby was nominated.
I'm with you guys on this.
Okay.
I hear you. We understand this. We have made this very clear that there needs to be more diversity on the federal bench that reflects the country.
So if Senator Grassley could just maybe help out with reaching out to his colleagues in the Senate. He's been a senator for a long time. He's highly esteemed in the Senate, and he does have his leadership position, and we do appreciate his commitment to diversity, and would just ask that he also use some of his clout to talk to his colleagues and encourage them when they're selecting judicial nominees to look for diversity, and we appreciate your commitment to doing so.
Yes, and that's I agree with you on that.
We probably have time for one more.
I'm Clay Latimer from the Louisiana Courts Matter Coalition, and I want to let you know that because of the development of these coalitions nationwide, Senator Grassley has become a national figure, and I really appreciate this opportunity to have been able to be part of this discussion with his office. So thank you very much.
I appreciate your guys' calling. I'm happy to have discussions with you guys anytime, and I would just say this: I'm a straight shooter. Senator Grassley is a straight shooter. I will give you direct answers to any of the questions you have. I'll tell you what's working, what's not working. I'm happy to do that, and I'm happy to talk to you anytime. I would just encourage the groups on all sides to try, to the extent that you can, to set aside the partisanship and the ideology and just have a discussion. And there's a lot of room for agreements with the outside groups. And your concerns are very much noted and appreciated. And I'm happy to talk. Like I said, I'm happy to do these conference calls anytime you want.
We appreciate that. Did you have one?
Yeah, just one other quick question about process. The American Bar Association ratings used to be a big deal, and I'm curious if you guys are still considering their ratings in your process when vetting nominees. It hasn't come up yet in this conversation.
The ABA rates the nominees. We work with Pam Bresnahan and Denise Cardman from the ABA. any outside group who wants to weigh in on the process, we encourage it. They don't have veto authority. No outside group has veto authority over a nomination, but we certainly consider their nomination, their recommendations on the nominations. There was a nominee from Kansas who who got an ABA not qualified because she had only been a lawyer for like 11 and a half years instead of 12, and so we moved forward with her nomination, and she got overwhelming bipartisan support. Her name was Holly Teeter for the District of Kansas. She's on the floor. She was ABA not qualified, but she has wide bipartisan support. There was another nominee named Judge Steve Gross in the 8th Circuit in Nebraska. He was clearly qualified. He had been the number 2 in the Attorney General's office. He had a significant number of trials and appeals, clearly qualified, and he was rated not qualified by the ABA because he was pro-life. So,
That's not correct.
we move forward on that one.
That's why he got
Over the ABA's not qualified rating, but we certainly work with the ABA, and we have a very constructive working relationship with them.
Would you say that no pro-life candidate has ever been rated qualified by the ABA?
I know that this particular one was rated not qualified by the ABA.
But you think that that's only because he had an anti-choice record?
I think that was a big part of it, yes.
Was there nothing about his attendance at work or his gratuitously rude behavior, to quote their report?
That's interesting because we do our own separate vetting. Their report was with anonymous sources, and I'm glad that are you representing the ABA or who are you representing?
I'm with
because the report was a report with anonymous sources that we could not verify. They wouldn't tell us who these sources are, so it was anonymous hearsay, drive-by shootings by people who would not put their name forward, so we can question them ourselves.
Not a good reference.
Not the best reference.
So we had anonymous allegations against a person who was universal. We looked at the letters from thousands and thousands and thousands of Nebraskans. We looked at the background investigation that's confidential. We can't talk about what's in it, but we looked at his full record, and we found nothing to substantiate the allegations that the ABA made.
So going back to the ABA process, chairs used to wait until they had the ABA rating before having hearings, and that hasn't been what's happening for all of the nominees.
Well, I mean, we generally schedule the hearings. We have what's called a 28-day rule in the Senate Judiciary Committee. It's not really a rule; it's generally a courtesy, and we work with our counterparts on Senator Feinstein's staff, the ranking member staff. And what we do is, once the nominations are here, along with the Senate Judiciary questionnaire and the attachments that the senators or that the nominees send up, we generally wait 28 days until after all the nominations and the paperwork are up here before, at least 28 days before we schedule a hearing. And we give the ABA plenty of advance notice of the hearings. If we generally want to work with them, and we have been working with them, we're going to move forward on nominations. We're not going to let outside groups control the nominations process. The nominations process is controlled by the senators who are elected by the people, not by outside groups. And so we encourage all outside groups to cooperate, but we're not going to give an outside group veto authority over a nomination. You guys are talking about the Constitution. I didn't see that in the Constitution.
Mike, it's right at 2:00 here, and so we've got this room reserved for an hour, and so unless Sue has one last final thing to say, but Mike, I'm going to let Sue finish up here now.
I just want to wrap up by saying, first of all, I don't think you were here when we talked about that we have had 67 people from 17 states, and about 40 of us are here in this room. So we are all been working on the federal judiciary, and I'll look to Senator Grassley for his leadership. On a personal note, I would lose the drive-by shooting reference in this day and age. I don't think that's a very good analogy when you're talking about something and was kind of very distressing to some of us. So just as a
well, I apologize for my stressing remark.
And thank you for taking the time to listen to us. and we look forward to working with you in the future.
And like I said, I'm happy to talk to any constituents anytime about the judicial process, so feel free to reach out.
Sure, that'd be great. And one more parting thought, and this maybe is to Carol as well. So Senator, we very much appreciate you all, even when we disagree, staff almost always takes the time to hear our concerns. I would love to, we've extended this invitation to Senator Grassley before, but he hasn't held a public town meeting in Polk County since at least, for at least 7 years. So would love to have that type of open forum in Polk County, Lynn County, Blackhawk County, Woodbury County, Story County. Those are the larger counties in the state. He has not held public meetings, so there's obviously a lot of things to discuss, and we'd love to have him visit us in some of the larger counties as well.
Thank you, Mike.
Thank you.
Thank you.
Thank you.
Got it?
Got it.
All right. Drew, I'm sorry, your storage is...
No, that's perfect. That's what I need. That's right. Yeah, okay. We can do like one-on-ones. Yeah. So we just left Senator Grassley's office and had a very frustrating conversation with his staff on the Judiciary Committee. We have folks from all over the country who came here to voice their concerns about the courts, and what we met was a really dismissive and frankly rude representative of his staff, and kept shifting and telling us one thing then another. And so we all of us will continue our work to call on Senator Grassley to stop politicizing the Judiciary Committee, and also to support a diverse and fair court system. So we'll continue pushing him to do that, and we hope that we'll have a better interaction with his staff the next time.
Okay, we're ready.
Yeah. We asked some really tough questions of Senator Grassley's staff about their opinion of some of the comments some of the nominees have made, especially about LGBTQ Americans, about LGBTQ Iowans. I don't think we really got satisfactory answers, to be honest. They deferred to process. They didn't answer any questions about the statements. We are really concerned that these folks are not going to be fair to LGBTQ Iowans, to LGBTQ Americans. If you are, calling somebody's marriage a crime against nature, that does not mean you're going to get a fair say in court, right? That's stacking the scales. And so we want a fair-minded constitutionalist in the court, not extremists.
Hi, my name is Chris Kang. I'm former deputy counsel to President Obama, and we just had an opportunity to talk to Senator Grassley's staff about why he's not showing independence when it comes to evaluating President Trump's lifetime appointments for the court. We think that these judicial appointments deserve more scrutiny, more time, and more consideration, and if the Senate took that opportunity, more of these nominations would be rejected, as they should be.
Close?
Nope, you're good. Okay, name and who you're with.
Hi, I'm Jody Rabham with the National Council of Jewish Women. We just came from a meeting with Senator Grassley's team, Judiciary staff in Washington, and his staff here in Des Moines. And I have to say it was a pretty surprising meeting. We had a lot of information that we wanted to share, a lot of questions, and we really were met with a lot of resistance. I could even say hostility, and not the most respect. There's a lot that we need to hear from the senator. He's in a very powerful position, and he's in a national position. And what we're seeing with the courts, what we're seeing, the lack of process specifically in the Senate Judiciary Committee related to judicial nominees and these lifetime appointments is incredibly troubling. And when you've got a group this size from across the country taking the time to come to Iowa and staying to go meet with the senator's staff, I think the least we could ask for is answers to our questions and some respect.